The fourth bucket that we now move on to is defects. Under defects, we're speaking of warranties, and there are 8 rules. Under these 8 rules, 4 of which are warranties. Those 4 rules for warranties are 2312, which is warranty of title, 2313, which is express warranty, 2314, implied warranty of merchantability, and 2315, implied warranty of fitness for a particular purpose. Then we have 4 other rules, which are 2316, which is your disclaimers, 2607, which is your notice of breach, and 2719, limitation of remedies. Oh, and then my apologies. Also, under 2312, warranty of title, I also snuck in 2403, which is the entrustment rule. So that goes back under warranties. Now, 2312, warranty of title. Under subsection 1, it reads, subject to subsection 2, and a contract for a sale, a warranty, and subject to subsection 2, and a contract for sale, a warranty by the seller that A, the title conveyed shall be good and its transfer rightful, and B, the goods shall be delivered free from any security interest, lien, or encumbrance of which the buyer at the time of contracting has no knowledge. Subsection 2 reads, a warranty under subsection 1 will be excluded or modified only by specific language or by circumstances which give the buyer reason to know that the person selling does not claim title in himself, or that he is purporting to sell only such right or title as he or the third party may have. Under subsection 3, a buyer who furnishes specifications to the seller must hold the seller harmless against any such claims which arises out of compliance with the specifications of the buyer. So in other words, it's just saying if the buyer is making specifications that actually cause the seller to kind of like breach this warranty of title, then the buyer must hold the seller harmless if it arises out of their compliance. Now, under warranty of title, there is also a separate rule, which is 2403, which is the entrustment rule. And 2403 is the name of the title to the actual rule is power to transfer, good faith purchase of goods, and entrusting. There are 3 subsections under this rule. The first subsection reads that a purchaser of goods acquires all title which his transferor had power to transfer, except that a purchaser of a limited interest acquires rights only to the extent of the interest purchased. A person with voidable title has power to transfer a good title to a good faith purchaser for value. When goods have been delivered under a transaction of purchase, the purchaser has such power even though A, the transferor was deceived as to the identity of the purchaser. B, delivery was in exchange for a check which is later dishonored. C, it is agreed that the transaction was to be a cash sale. And D, the delivery was procured through fraud, punishable as larceny under the criminal law. Subsection 2 reads, any entrusting of possession of goods to a merchant who deals in goods of that kind gives him power to transfer all rights of the entruster to a buyer in ordinary course of business. That is the entrustment rule. And I'll read that one again. Any entrusting of possession of goods to a merchant who deals in goods of that kind gives him power to transfer all rights of the entruster to a buyer in ordinary course of business. Subsection 3 reads, entrusting includes any delivery and any acquiescence and retention of possession, regardless of any condition expressed between the parties to the delivery or acquiescence, and regardless of whether the procurement of the entrusting or a possessor's disposition of the goods have been such as to be larcenous under the criminal law. I probably wouldn't write out number 3, actually. Okay. The second warranty is express warranty. Express warranties, the rule contains 2 subsections. Express warranties by the seller are created as follows. And there are three ways they are created. Any affirmation of fact or promise made by the seller to the buyer, which relates to the goods and becomes a part of the basis of the bargain, creates an express warranty that the goods shall conform to the affirmation or promise. B, any description of the goods which is made part of the basis of the bargain creates an express warranty that the whole of the goods shall conform to the description. And C, any sample or model which is made part of the basis of the bargain creates an express warranty that the whole of the goods shall conform to the sample or model. Under subsection 2, it is not necessary to the creation of an express warranty that the seller use formal words such as warrants or guarantees, or that they have a specific intention to make a warranty. It also does not create a warranty if merely by the value, merely an affirmation merely of the value of the goods, seller's opinion, or it does not create an express warranty when it's an affirmation of the value, the seller's opinion, or the seller's praise. So again, I'll do express warranties again. So express warranties are created by the seller, are created as follows, and there's 3 ways: an affirmation of fact or promise, a description of the goods, or a sample or model. It is not necessary to use words such as warranties or guarantees in order to create an express warranty. And it does not create an express warranty when either of the 3 occur, which is affirmation of value, seller's praise, or seller's opinion. The third warranty is implied warranty of merchantability. That's Rule 2314. There are 3 subsections under the implied warranty of merchantability. Unless excluded or modified under 2315, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to goods of the kind. Under this section, the serving for value of food or drink is to be consumed either on the premises or elsewhere is a sale. So in other words, it includes food and beverages as well. So part 1 just means that the implied warranty of merchantability applies to merchant sellers. And it's conveyed when there is a merchant seller, and it also includes food or drink to be consumed either on the premises or elsewhere. That's subsection 1. Under subsection 2, goods to be merchantable must at least fulfill one of these 3. A, it must pass without, goods to be merchantable must at least fulfill these 3. Pass without objection in the trade under the contract description, and are fit for the ordinary purpose for which the goods are used, and are adequately contained, packaged, and labeled as the agreement may require. So I'll read subsection 2 again because it's an and thing. Goods to be merchantable must at least A, pass without objection in the trade under the contract description and are fit for the ordinary purposes for which the goods are used and are adequately contained, packaged, and labeled as the agreement may require. Subsection 3, unless excluded or modified under 23116, other implied warranties may arise from the course of dealing or uses of trade. So in other words, I'm probably not gonna mention part 3, but I'm going to reread implied warranty of merchantability again. Under subsection 1, if there is a merchant seller, it is automatically warranted that the goods will pass without objection in the trade under the contract description, and they are fit for the ordinary purposes for which the goods are used, and they are adequately contained, packaged, and labeled as the agreement requires. And the fourth and final warranty is implied warranty of fitness for a particular purpose, which is Rule 2315. Where the seller at the time of contracting has reason to know of any particular purpose for which the goods are required, and 2, that the buyer is relying on the seller's skill or judgment to select or furnish suitable goods, there is, unless excluded or modified under the next section, an implied warranty that the goods shall be fit for such purpose. So in other words, there's really just basically 2 things to be mindful of under the implied warranty of fitness for a particular purpose. It's that at the time of contracting, when the seller has reason to know that in the particular purpose for which the goods are required, and the buyer is relying on the seller's judgment to select or furnish suitable goods. Disclaimers of warranties under 2316. There are 3 subsections. Words or conduct relevant to the creation of an express warranty and words or conduct tending to negate or limit the warranty shall be construed whenever reasonable as consistent with each other, but subject to the provisions of the UCC on parallel or extrinsic evidence under 2-02. Under subsection 2, actually, there's 4 subsections here. Under subsection 2, subject to subsection 3, to exclude or modify the implied warranty of merchantability or any part of it, the language must mention merchantability, and in case of a writing, must be conspicuous, and to exclude or modify any implied warranty of fitness, the exclusion must be a writing and conspicuous. Language to exclude all implied warranties of fitness is sufficient if it states, for example, that there are no warranties which extend beyond the description of the face hereof. So for the implied warranty of merchantability, it must specifically mention the word merchantability. And in the case of a writing, it must be conspicuous, right? So it doesn't necessarily have to be in writing, but if it is in writing, it must contain the words merchantability and it must be conspicuous. To exclude or modify an implied warranty of fitness, the exclusion must be by writing and it must be conspicuous. Language to exclude all implied warranties of fitness is sufficient if it states, for example, that there is no warranty which extends beyond the description on the face hereof. So basically a general disclaimer. Then for subsection 3, it reads, notwithstanding subsection 2, and there's 3 clauses underneath this. A, unless the circumstances indicate otherwise, all implied warranties are excluded by expressions like as is, with all faults, or other language, which is common understanding, calls the buyer's attention to the exclusion of warranties and makes plain that there is no implied warranty. And B, when the buyer, before entering into the contract, has examined the goods or the sample or model as fully as he desired, or has refused to examine the goods, there is no implied warranty with regard to defects which an examination ought, in the circumstances, to have revealed to them. And C, an implied warranty can also be excluded or modified by course of dealing or course of performance or usage of trade. And number 4, remedies for breach of warranty can be limited in accordance with the provisions of the UCC on liquidation or limitation of damages and on contractual modification of remedy under 2718 and 2719. So in other words, to sum all of this up, the implied warranty of merchantability disclaimer must include merchantability, either orally or if it's written, it must be conspicuous and include bold print, all caps, and the like to draw readers' attention to disclaimer in some way. The express warranty can be expressly disclaimed, can be made in the same manner. It can be disclaimed in the same manner it was created, which is expressly. Implied warranties for fitness for a particular purpose can be disclaimed, must be disclaimed in writing, and it must be conspicuous. Implied warranties are excluded by language such as is, or with all faults, and similar language that calls the buyer's attention that there is no implied warranty. When a buyer examines or refuses to examine a good, there is no implied warranty for defects that would have been revealed upon examination. Notice of breach requirement. Under Rule 2607, the buyer must pay, there's 6 subsections here. 1, the buyer must pay at the contract rate for any goods accepted. 2, acceptance of goods by the buyer precludes rejection of the goods accepted, and if made with knowledge of a nonconformity, cannot be revoked because of it, unless the acceptance was on the reasonable assumption that the nonconformity would be seasonably cured, but acceptance does not itself impair any other remedy provided by the UCC for nonconformity. 3, where a tender has been accepted, A, the buyer must, within a reasonable time after they discover or should have discovered any breach, notify the seller of breach or be barred from any remedy. And B, if the claim is one for infringement or similar to 2312, and the buyer is sued as a result of such a breach, they must notify the seller within a reasonable time after they receive notice of the litigation or be barred. 4, the burden is on the buyer to establish any breach with respect to the goods accepted. 5, where the buyer is sued for breach of warranty or other obligation for which the seller is answerable over, may A, give the seller written notice of the litigation. If the notice states that the seller may come in and defend, and that the seller does not do so, they will be bound in any action against them by their buyer. If the claim is one of infringement or the like under 2312, the original seller may demand in writing that the buyer turn over control of the litigation, including settlement, blah, 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 or else be barred from any remedy. 6, the provisions of subsections 3, 4, and 5 apply to any obligation of a buyer to hold the seller harmless against infringement or the like. Contractual modification or limitation of warranties, which is Rule 2719, called contractual modification or limitation of remedy. And there are 3 subsections here. Subsection 1 reads, subject to 2 and 3 of this section and the preceding section on liquidation and limitation of damages, A, The agreement may provide for remedies in addition to or in substitution for those provided in the UCC, and may limit or alter the measure of damages recoverable under the UCC, as by limiting the buyer's remedies to return the goods and repayment of the price, or to repair and replace non-conforming goods or parts. And B, resort to a remedy as provided is optional unless the remedy is expressly agreed to be exclusive, in which case it is the sole remedy. Subsection 2 reads, where circumstances cause an exclusive or limited remedy to fail of its essential purpose, remedy may be had as provided in the UCC. Subsection 3, consequential damages may be limited or excluded unless the limitation or exclusion is unconscionable. Limitation of consequential damages for injury to the person in the case of consumer goods is prima facie unconscionable, but limitation of damages where the loss is commercial is not. Okay, now we move on